Well, I would like to welcome all of you to the lecture on Judicial Control over Administration. Now, the point to start with is that democratic government requires control because the very institution of government has the message or the duty of carrying the interest of the governed, and the responsibility and powers is distributed between the three organs or wings: the executive, legislative, and judiciary. Of this, judiciary is the most important or vital pillar of maintaining democratic government. The role of judiciary is not the same in every country. In United States, the judiciary has got the responsibility of seeing that laws framed by the Congress or the decisions taken by the President is correctly made according to the law of the country. In India, the judiciary, the highest judicial body, the apex court, doesn't have the flat authority like the American Supreme Court to review whether due process of law is followed or not. In India, it is provided in the Constitution that highest judicial body will be examining whether the procedure laid by law has been followed. But, for example, in America, this judicial power or intervention to review the decisions of the legislature and of the executive emanated from Chief Justice Marshall's historic ruling in 1803 that it is emphatically the province of the judiciary to see that due process of law has been followed or has been made. And he said that under the American Constitution, it is the judiciary which is empowered to say what is the law. That is, the final position of the citizens vis-a-vis the state is determined in a sense by the judiciary, the highest court. In India, we also find that our Chief Justice of the Supreme Court, Patanjali Shastri, in early 1950s made a point that it is the duty of the Supreme Court to see that citizens enjoy their fundamental rights. Supreme Court is entitled to see that rights of the people are not infringed either by the legislature or by the executive. Our recent experience shows that in India there is a major allegation made by the politicians, media, and the general public sometimes of what is called judicial activism or judicial overreach. So in that canvas, we have to see the distinction between the due process of law in America and the procedure established by law in India. Judiciary can declare laws and executive actions unconstitutional and therefore ultra vires and therefore void. In 1960s, the Supreme Court defended the rights of the citizens in a famous case, Goloknath versus State of Punjab, and stated that fundamental rights of the citizens cannot be mutilated or restricted. Lately, that is last year, 2015, we find that a 5-judge bench of the Supreme Court has nullified and struck down the Act of Parliament creating the National Judicial Appointment Commission. So this shows that we have got a system of judicial control over administration, including control over the legislature. In the sense that nothing will be allowed by the judiciary to vitiate the atmosphere of freedom and rights of the people. And the people have got the basic right, judiciary views, and even all scholars of political science and jurisprudence views that right to life, right to liberty, and right to property. It is as old as John Locke's assertion in his second treatise of government in England. That is in a sense the starting point of organized democracy in the world. And therefore now best position to take is that in a system of democratic governance, it is not a question of judiciary versus executive or judiciary versus parliament. The point is that nobody is supreme, neither the judiciary nor the executive or administration and parliament. What is supreme is the Constitution. It is the Constitution which has to be defended by the Supreme Court. In India, the Supreme Court and the High Courts, they have been empowered to scrutinize laws and the actions taken by the administration to see whether they have infringed upon the rights and privileges or democratic entitlements of the citizens. That is to say, the first thing which has been given in the Constitution, we have a written constitutions, in India, that fundamental rights are given to the citizens which must not be invaded, injured and jeopardized by any way by the state, that is the executive and legislature. It is the preeminent responsibility of the judiciary to do that in order to protect, safeguard public interest in general and the decision of the and the citizens and their rights. The court can review the even presidential proclamation of emergency under Article 356 of the Constitution. That is, if at any time the President is satisfied that constitutional government cannot be carried on in accordance with the constitution in a particular state, then he may proclaim as advised by his cabinet that the elected government be dismissed there. Now from 1992 onwards, we find that judiciary has made it even a justiciable point, justiciable item. That is, Supreme Court has assumed the power, even the High Courts have assumed the power of judging whether action taken under Article 356 of suspending or dismissing a state government, including the legislature and the executive, whether they are correct or not, whether they are according to law or supported by facts and evidence, etc. So this shows that the entire space reserved for judiciary control over administration is quite big now in India. Admittedly, judiciary itself is not free. Everybody knows from its own limitations or blemishes and stigmas. Sometimes there is allegations of bias and corruption, in particular judges in the upper judiciary, and therefore it is not uncommon that what is supreme in India or in a democratic country is the constitution as interpreted by the Supreme Court or the High Court sometimes. Point is that judiciary's basic function is to see that I have just pointed out, is to protect the interest of the citizens or the public interest in general, that is their right to enjoy life, liberty and their property. Now all these expressions have their implications. Right to life, as given in Article 21 in our Constitution, has since been widely expanded by the rulings and observations of the Supreme Court. That is, now right to a decent life, right to good environment, right to good food, everything has been good and adequate food, everything has come under the judicial review or judicial supervision. And we have got now accustomed with certain welfare measures introduced by the administration, for example midday meal, National Employment Guarantee Scheme or Sarva Shiksha Abhiyan, or any project for protection of the interest of women, of the girls, of the child, of the destitute. Everything now comes within the purview of Supreme Court's observation and necessary directions. Even when there is large-scale drought or floods and the court thinks that the state is failing, then we see now the Supreme Court is issuing directives to the government that you must do such and such thing, you must take immediate steps to protect life and the property of the citizens, you must take care of the interest, protecting the interest of the child, protecting the interest of the minority, so on and so forth. So this is how we come to know how judiciary has emerged as a very important pillar of democratic governance in our life in nowadays. Now this necessity of maintaining judicial supervision over the other two organs of the state has given rise to the concept of rule of law as devised by famous English constitutional scholar, a jurist, A.B. Dicey. The Dicey's concept of rule of law is that the system of governance must be no respecter of persons or authority or position in actual life. It must be equal for all, and there must not be any bias of application of law. Now, judicial intervention, one thing is certain. Now we find that judiciary's right to intervene in matters of public interest, in matters of public administration, in matters of controlling the council of ministers and vis-a-vis the bureaucracy, etc., all oriented to the basic idea of preventing misapplication of justice, preventing injustice done to the citizens. Now, the judicial intervention can be of basically 5 types, I say. First, judiciary can intervene because of lack of jurisdiction, number 1. Number 2, if there is an error of law. Number 3, if there is any error of facts. Number 4, if there is any abuse of authority. And fifthly, if there is any error of procedure. So these are the 5 categories of instances in which judiciary can intervene and control administration. The judicial remedies are available in the form of writs. W-R-I-T-E-I-T, writ. Writ is a judicial command. Now, they can be understood again under 2 basic type of governance. One is called the system of rule of law, as I have just said, explained. Another is system of what is called system of administrative law. System of rule of law means that citizens and organizations or anybody and the administrator and the ministers or the government personnel, so everybody must be treated equally in the eye of law. Law must not be special respecter of persons. But in system of administrative law, as we find it in prevailing in the continental countries, especially France, Germany, and to some extent in Russia, is this that judicially the official administrators, bureaucrats or government officials, when on duty, they cannot be sued in the ordinary courts of law. Their case, even when they made an error or injustice to somebody, that has to be taken to a separate system of courts called administrative law. So there are seasoned judges who are also, some of them mostly senior retired administrators. They will scrutinize the rules, regulations and the laws of the country and to find out whether the type of damage it has caused to the citizens or whether it is the citizens who are at fault vis-a-vis the functioning of the administrators in the field. So this way, if there is any system of what is called in law tort, tort, then the suitable damages are also sanctioned in favor of the citizens. They can get compensation. Now in India, the judicial writs can be issued by the Supreme Court under Article 32 and also by the High Courts under Article 226. The Supreme Court can issue writs, any of the writs that I will just explain right now, if it is satisfied about the merit of the case. Only in case of violation of fundamental rights. But high courts are empowered to intervene under Article 226 on the same ground, that the violation of fundamental rights or any other grounds. So high court's jurisdiction is wider in that sense. Now come to the writs one by one. The judicial writs, first most important and very ancient, habeas corpus. That means let us have the body before us. Then this writ, when issued by a person whose liberty has been damaged and restricted by the state, by the administration, the court may say, you bring the person in front of us. So that is, and the court will decide whether detention is legal or not legal. So this is called the writ of habeas corpus. Second one is mandamus. That is, we command, the court commands, mandamus. The court may say that is command, it is a command of the court that certain procedure must be followed, certain procedures, decisions must be nullified, or this way or that way. It can make some sort of direction, some command which must be accepted or followed by the administration. Thirdly, there is prohibition, that is some sort of a mandate given to the lower courts that you must not act in this way, that is prohibits, that's called prohibition. That is, lower courts are prohibited from taking actions. Certiorari, that the court certify, we certify, that is called certiorari in Latin. Now again it is a control over subordinate courts, and the lower courts' decisions may be supported or nullified by the higher judiciary, and they certify to that extent. And last of all, quo warranto, that is under what authority. Now this also applies to judicial or judicial or quasi-judicial bodies. That is, higher court may want to know under what authority you have taken this action, whatever the actions, whereby the interest of the public or interest of any official, interest of any group has been violated. So these are the normal procedure whereby the judiciary, higher judiciary or judiciary as such can intervene. Now since 1981, there has been a development in India which is unique, that is Public Interest Litigation, very popularly known as PIL. Now PIL has began the transfer of judges case or SP Gupta case in 1981, but it was widely and formally formulated by Chief Justice P.N. Bhagavati in 1984, where he explained that PIL is the strategic arm of the legal aid movement, bringing justice within the reach of the poor, the vulnerable, the helpless citizens who cannot approach formally the court of their own because they don't have the necessary means to do that, and therefore public interest litigation can be made by any person who have sufficient public interest to serve on behalf of a person or group of persons who have suffered, where dignity has suffered, whose rights have suffered. Now in Bhagalpur blinding case, it was found that a group of prisoners, their eyes were taken away by the prison authorities, but nobody knew about it until a reporter made a report in the newspaper and the court took notice of it and took action. then a member of the public having sufficient interest may write even a letter to the court, not coming to the court as just a postcard will do, and the court will take necessary action and will proceed with the case and given the remedy. Because after all, the judges argued that we cannot deny the citizens right when they are knocking at our door. Since the poor, vulnerable, neglected, marginalized sections of the people are suffering most, so PIL is the most democratic instrument devised by Indian Judiciary to protect the interest and public interest of the groups and effectively. Now judicial, this is the beginning of judicial independence effectively seen. But there is some limitations and dangers also, with the court itself has from time to time pointed out that in the name of public interest litigation, it must not be allowed to degenerate into private interest litigation or degenerate into publicity oriented litigation. So all these must be prevented, otherwise other people in large, parliament, executive, everybody will limit the action and the jurisdiction of the court. So court itself must take care that PIL must not be misused. PIL is just a safety valve and must be used cautiously without mutilating the constitutional and the laws. So this is the general atmosphere and the arrangement of legal institutions and the procedures that protects the interest of the people of India and group of people, especially those who have no means or whereabouts worthwhile to approach the court when their rights are endangered, when their interests are jeopardized. So this is how the judiciary can control the administration. I think that is enough for the day. Thank you.